want this forever, just you in the grotto.
Let's imagine that you own a property in an older area of a city that is the focus of a new overlay plan to spur redevelopment in that area. You attended the open house hosted by the municipality, and at that event you saw a proposed land use map that shows your property being designated for future commercial use, even though you currently live there and have no plans on moving. So what does this mean for you if the plan does get approved? To get the answer to this question, the first place to check is the Municipal Government Act, or MGA. It's a provincial law that regulates how municipalities in Alberta govern and shape their communities. Basically, it outlines the procedures and requirements for governments to operate lawfully. So, although you may not have heard of it, the MGA actually affects the average person more than you think. Think of it as the man behind the curtain we were told not to pay attention to in The Wizard of Oz. It's all-powerful and controls most everything that happens in government, and municipalities refer to it to solve their issues when faced with a challenge. If I was a lesser person, I'd also jokingly make a connection about the wizard being a con man when the MGA is actually approved by politicians, but I'm above that type of humor. Anyways, the ways in which the MGA affects the average person aren't necessarily all direct, but they do exist. The Municipal Government Act regulates who can be elected to council to represent your interests, what a municipality can do with the properties within their boundaries, like taxes, levies, expropriation, and outside their boundaries, like annexation, how municipalities pass and enforce bylaws, and of course the planning and development processes a municipality can undertake. It's a lot and is nearly 600 pages long, so that's why every municipality in Alberta employs a legislative clerk whose main responsibility it is to completely understand the MGA and make sure that it is always being followed by the municipality. If not, the municipality opens itself up to being sued. Beyond setting the tone for municipalities, though, the MGA protects the rights of property owners. It gives property owners the rights over their properties, but not the mines and minerals underneath. It does also give people the right to participate in government processes. And finally, it protects property owners in the event of a development process that directly affects their lands. So that last point is the main topic of this video. You may hear people talk about grandfathering, which is basically just a layman's term for the MGA regulations around non-conforming buildings or uses. Basically, grandfathering exempts a person or a property from adhering to a new law or regulation because they were there first, before the law was adopted. Going back to the example from the opening of the video, showing up to an engagement event and seeing that your property is designated for commercial land may make a person ask, does this mean I can't live there anymore once it gets approved? As a consultant, it's the most common question I get asked at public engagement events. The good news is that the MGA protects the rights of those that are there prior to the new rules being enacted. The bad news is that it isn't complete protection. Section 643 of the MGA outlines the ways in which a landowner is protected, along with a few caveats. Basically, a landowner can continue to use their property as they always have, in perpetuity, which is a fancy legal word for forever, as long as it remains the same in terms of size and intensity. So, using our example from the beginning, as a homeowner, you can continue to live in your house as long as you want. You will not be required to adhere to the new commercial zoning until you go to redevelop. That is, unless one of the following circumstances is met. Number one, the use stops for a period of 6 consecutive months or longer. So if you stop living in or otherwise occupying your house with renters, this clause kicks in. In my experience, it's difficult for municipalities to prove a 6-month vacancy for residential, but it is still a good reason to have and hang on to formal rental agreements and rental receipts if you do rent your place out. For non-conforming commercial buildings, make sure that you have current business licenses to operate out of the space to prove continuity. Number two, the structure changes or enlarges. So you cannot build additional buildings that require permits or enlarge the existing buildings in any way without conforming to the new regulations. This one is a bit complicated because technically it can outlaw things like garages and decks if they aren't permitted in the new zone. The MGA does allow for regular maintenance though, but nothing new and nothing that enlarges the existing footprint. Number three, the structure is damaged by more than 75% of the value in the event of a fire or other disaster or event. So basically, if the house burns completely down, it can't be replaced with another house. It has to conform to the new rules. In our example, it has to be rebuilt as a commercial development. So not a perfect situation to be in, but the MGA does offer basic protection to make sure owners aren't forced out of their homes with every approved overlay plan. The MGA also allows for land ownership to change without affecting the grandfathered status, so as a homeowner, you're still able to sell your home even if it is non-conforming, and those buying the home are still able to live there for as long as the conditions are met. Once the property is redeveloped, though, it does have to conform to the new regulations. It's kind of like having an older phone with older software on it and being asked to update to newer software. Maybe you're like me and you have a tinfoil hat on pretty tight that makes you believe that upgrading to the newer software will breach your privacy and data in some way. So you don't update the software, you always just click no and use your phone as you always have. The phone company, nor the phone manufacturer or the software manufacturer can make you update the phone, and you can keep using the older software as long as you want. But if you were to break or lose your phone, the new phone you'd have to go buy from Best Buy would have the new software already on it. So the point I'm trying to make here is that the MGA protects your rights as a property owner to keep doing your thing. Sorta. This has been Ryan with Irons Consulting. Thanks for watching.
I want this forever, just you in the grotto with nothing but your nights on. Keep the fucking lights on, same again tomorrow.